Good morning for those of you for whom it is morning, and welcome to the Monday plenary session of the 27th Annual Law and Religion Symposium of the International Center for Law and Religion Studies. My name is Brett Scharffs, and I'm director of the center. This morning, it is my particular pleasure to pay tribute to my friend and colleague, my mentor and model, Professor Cole Durham, the founding director of the International Center for Law and Religion Studies. I have been Cole's junior partner since the day I started my career as a law professor at BYU in 1997. My hope today is to honor him without making him feel like he is attending his own funeral, and without giving him the impression that he can now ride off into the sunset. Since becoming director of the center 4 years ago, one of my main priorities has been to take enough of the administrative burden off Cole's shoulders that he would have the energy and inclination to continue the work he does so well that only he can do. When people ask me, what is it like to be director of the center, I put it like this. For 20 years, I was Cole Durham's junior partner, and then I became director and everything changed. Now, I am Cole Durham's junior partner. This description sometimes elicits a chuckle, but it is true. Cole remains my senior partner in all of our work. Bill Atkin, the International Council for the Church of Jesus Christ of Latter-day Saints, and one of Cole's most important partners in the work of religious freedom, once paid tribute to Cole in a way that I've never forgotten. As Bill describes it, he and Cole were on a long-haul flight back home after one of 100 international conferences they had attended together, and it was the middle of the night, and Bill had gotten up to use the restroom on the plane. As he walked down the aisle, he saw Cole, with his 6-foot 4-inch frame shoehorned into an economy class seat, with his laptop opened and his shoulders and head falling forward. Cole, who had been hard at work, as usual, had fallen asleep, literally with his fingers on his laptop keyboard. As Bill recounted this story, my mind's eye was taken to similar scenes I have witnessed. Bill described a scripture that came to his mind as he looked at Cole. It's from section 123 of the Doctrine and Covenants, a book of revelations received by the prophet Joseph Smith. And it was written from the dark and freezing confines of the inaptly named Liberty Jail, where Joseph spent a cold winter in Missouri on false charges, while his people were subject to what the governor of Missouri styled an extermination order, calling for open season on the Latter-day Saints living in the state of Missouri. From Liberty Jail, Joseph wrote a letter, one of the greatest examples of prison literature ever written, ranking with the letters from Paul and Martin Luther King's letter from a Birmingham jail. Joseph's letter was later canonized and comprised sections 121, 122, and 123 of the Doctrine and Covenants. In section 123, Joseph describes what the saints should do in response to the persecution they were experiencing. He emphasized the importance of gathering up knowledge of all the facts of what people were experiencing, including the loss of life, personal injuries, and property. He also emphasized the importance of gathering information from magazines and other publications that include libelous slanders. He described, quote, the imperative duty that we owe to all the rising generation and to all the pure in heart. Bill then quoted the verse he thought of as he saw Cole hunched over his laptop in exhausted sleep. Verse 13 reads, therefore, that we should waste and wear out our lives in bringing to light all the hidden things of darkness, let us attend these things, quote, with great earnestness. The next verse says, let no man count them as small things, for there is much which lieth in futurity, which depends upon these things. The passage continues, you know, brethren, that a very large ship is benefited very much by a very small helm in the time of a storm, by being kept workways with the wind and the waves. That was the image Bill had of Cole in the dark night on that long flight, a man who was willing to waste and wear out his life, bringing light to dark places, and doing so with great earnestness, positioning himself headlong into the storm, workways with the wind. Since that description of Bill, that is the image I've had in my mind's eye of my friend and colleague Cole Durham, who is also my mentor and model. Thank you, Cole, for what you've done and for what you do, but more for who you are and who you've become. We will now watch a video tribute to Professor Cole Durham.
When I came to teach at BYU from year one, I wanted to teach courses on law and religion, church and state, religious freedom. Over time, I realized that this is simply an immense field. And I would say I've taught for 43 years, and I've taught courses on this one or more every year. And there's always new things. So I think it's been a long period, long time interest, fascination. It's also been connected to a deep sense of what's really important in life.
I met Cole Durham for the first time somewhere in the 1990s, and that was in Poland, and that was in the run-up of what later would become the Advisory Council of Freedom of Religion or Belief of the Office of Democratic Institutions and Human Rights of the OSCE. And it was wonderful because it was a very new development, and it was not certain that such an advisory council would be established. But I think that also those early meetings, in which Cole also played a very prominent role, were very helpful in convincing ODIHR that such a center, such an advisory council would be worthwhile.
I just remember so many times of being able to have breakfasts with Cole at different venues in China, and talk about how could things be different, and I think Cole has a real vision for how the world can move forward on this issue, and I think that's certainly one reason that the center has been successful, is you've had someone that sees the future in a positive light and sort of invites people to come along, and he never tires of working on this issue with a big heart.
Cole is like, I don't know, my hero. Everybody should be Cole, in the sense of being everywhere all the time, full of energy and goodwill and good grace. And I think, we do these dialogues on tolerance, and we call the first speakers, myself and Shannon Minter and other people, dialogue catalysts. Well, Cole has really been a catalyst for religious freedom, but not dialogue by dialogue, almost like continent by continent, country by country. How many people in their lives can say that, right? That they've had that kind of impact across so much space and across so many relationships. I think it's just a lovely thing.
Thank you so much for the opportunity and trust that given to me to work with the center, as well as for being my teacher.
I had a problem with Cole Durham. He was always working. He was never ill, never sleeping. And then I felt guilty at some stage. So it was a relief to me the few times that he overslept, that he came a little bit later, that the car or a bus had to wait a few minutes for him. He was a human. Also, Cole Durham was a human. That's nice news, and I felt relieved.
Cole is a fascinating person because as he is doing now, probably 30 minutes before the final, he will be up in his office making notes, and he'll come out and make what you think took him 3 weeks to do, and he will have done it in 30 minutes. He is able to put together thoughts, which is an amazing process. he's very fast. When he sees a statute, a constitutional part, right away ideas come to his mind of how to improve it, how to change it. He can talk to anybody and they'll listen.
For me, one of the classic Cole moments was when we were in Nepal and helping with work on the Constitution, and that was, again, a very complex cultural set of interactions, and there were a lot of very senior government people involved and a lot of formality and importance that there was appropriate respect shown. And over the course of that conference, almost everybody came down with some form of food poisoning. But the last ceremony was obviously a really important moment, and it was very important for the Nepalese and for the government officials involved. So I remember Cole barely being able to stand and sort of almost being lifted, carried in by some of his colleagues to get to the stage, and looking as sick as I've ever seen Cole, who normally looks like a fairly healthy figure. But he was just determined to finish the job that we'd started.
My memories of Cole are of a man for whom personal relations are the high point of all he does in the course of his work. He is not the most strategic of organizers. He's one of the worst timekeepers I've ever come across. But he has personal connections with government ministers, with administrators, with practitioners, and with scholars. And his personal network of global connections is one of the most valuable things in the world of law and religion. Because I'm not the only person who would move heaven and earth to accept an invitation from Cole Durham. People everywhere will do that.
Knowing Cole Durham, it's been amazing to see how he's advanced that standard for religious freedom globally, more than any other person in the field. And in every country where I work or Cole works, we just collaborate to share contacts and information and to support each other. And so while I work on the education and more civil society side, and he works at the government level, an academic level, it's been a great symbiotic relationship and just mutually reinforcing in so many ways. And it's a blessing to have somebody like that in the field that you can collaborate with, that, and not just Cole, but the center, because I mean, what he's built has been this amazing network globally of individuals that can advance religious freedom.
That is an African saying. Translated loosely, it says, you cannot see an elephant and say, what did I just say? What just passed by? Cole is a giant in the field of law and religion. Our relationship is a colleague, but in the field of law and religion, I feel like a mentee whose eyes have been opened to such an important area. And for the since I met Cole at that conference, I've not done any research in any other area more than law and religion.
Cole is just that kind of person. He loves people. He's genuine, honest, good-hearted man who really tries to help. And all of us who are surrounding him really feel that he's our really best friend, and that each one of us is the best among all of them, you know?
You plant a seed, it grows a tree, but from that tree, other things, essentially, pollinate, and you end up with a forest. And, Cole has created a forest around the world of these people who are devoted to religious freedom. But when I first met him, I thought, this guy would have been an amazing Gadamerean philosopher. And now I look back and I think, wow, I'm so glad he didn't choose. I think he would have been great, but I'm so glad he didn't choose that path, because the difference he's made in the world is going to last for generations. And not that Gadamerean scholars don't make generational differences, they can, but the sort of difference he's made in a career is the sort of difference that institutions try to make, not just individuals. And he's done it.
Cole Durham has been an inspiration to myself and to others internationally in his quest for religious freedom and for how the law can support and buttress that. I know that he's retiring, but we won't let him go. It's absolutely vital that he stays with us for the Windsor Dialogue, which we hold in Cumberland Lodge and Windsor Castle every year now. So Cole's not allowed to disappear, and I'm absolutely sure that Brett won't let him either. So not much retirement looming, I fear, Cole. We're all after you now, and you may be even slightly freer to give us more of your thoughts in time. We can't let you go. Your vision is too powerful, and your capacity for explaining your vision is much too important for the rest of us. Thank you for what you've done. I'm looking forward to the next round.
I have to chuckle when I think that my friend Cole Durham is retiring, because when I met him over 2.5 decades ago in the 1990s, he was already the godfather of international law and religion and of international religious freedom, which became my field. In those days, I wanted to read what Cole Durham had written, and I did, and I became his student, and I'm happy to say his friend. So here, 2.5 decades later, I still consider him my teacher, my friend, and I am his student. On behalf of all the people around the world, Cole, the scholars, the victims of religious persecution and discrimination, and certainly on behalf of the Religious Freedom Institute and myself, thank you for everything you have done in your life.
Cole will not follow my advice, because I'm sure that for Cole, retirement is a word without any meaning, and I'm sure that he will go on working as he has always done.
It's a good joke, Cole Durham and retirement. We all know that Cole will never retire. That's my firm belief. That's my firm religious belief.
Cole, a great friend, a great mentor, a great man. I wish you the very best. I wish you a very fruitful and satisfying retirement. And I know that that word retirement may not absolutely apply to you, because I know the commitment you have for this cause. When I used to interact with you, I used to say it's a movement, the law and religion movement. And I think it is, and you cannot retire from a movement. So, Cole, I wish you the best. We are still with you.
Professor Renata Uitz started teaching at Central European University in 2001 and became chair director of the Comparative Constitutional Law program in 2007. She is the founding co-director with Professor CAROLYN of the clinical specialization at the Department of Legal Studies. Her teaching covers subjects in comparative constitutional law and human rights, with special emphasis on the enforcement of constitutional rights. Theories and practices of good government, transition to and from constitutional democracy, questions of personal autonomy and equality, including religious liberty and sexual autonomy, are at the center of her research interests. In the 10 years that I've been teaching at CEU, Professor Uitz has become a trusted colleague and friend. She has joined the casebook on law and religion by Cole Durham and me for the 3rd edition as a co-author. She has also participated regularly in our teaching and training programs in China, Vietnam, Myanmar, and Uzbekistan. I think she has known Professor Durham since she was a student, and she, as much as any other person, is responsible for the progress and success of the Legal Studies Department at Central European University. Renata, welcome.
I have known Cole Durham for almost 2 decades. First, I met him in the classroom at Central European University, that was still in Budapest. Over the years, we spent a lot of time together at conferences and workshops, and I also had the utmost privilege of seeing him interact with national and international civil servants who were preparing to draft or redraft legislation on church-state relations. I learned a lot from Cole over these years. More importantly, a lot I learned an equally great deal from watching him interact with civil servants, activists, church leaders, and especially watch him when his audience did not want to hear what he meant to say. The lessons I take away from these experiences are applicable amidst crises and across divides. They are, of course, very relevant for issues of law and religion, but they are especially instructive for any work on resilience and resistance strategies at an age when illiberal and populist political actors are steadily on the rise across the world. These political actors very often instrumentalize religion in order to sow the seeds of distrust and discord against minorities. And they use the law very often to demonize and stigmatize others, including religious minorities. Cole's work allows us to study the law, including legal rules these rulers make, and the workings of the law in a comparative perspectives. His work teaches us that we should focus not on a single event, no matter how dramatic or spectacular, but put legal rules into their broader context and make sure that we understand the larger trends. A very important stage in Cole's work coincided with the third wave of democratization. This was a time when countries seeking to transition to democracy had high aspirations for defending human rights. We had high hopes that international and regional human rights instruments and organizations will afford previously unseen degrees of protection to religious freedom. We also saw church-state relations in a new light. We understood historic status claims being relevant, but we also understood the willingness of a number of governments to do something about historic harms, to afford restitution, and also to be able to create a clean slate to bring in a new age of religious pluralism. It was at the time when the European Court of Human Rights tied constitutional democracy and religious pluralism together in a manner that was meant to form the foundation of the European human rights regime. In this period, Cole focused in his writing a lot of time and effort into explaining the harms that a relatively new Russian law that required the re-registration of religious organizations on very short notice caused to religious freedom. It was a very odd interest at the time because the Russian law clearly didn't follow trends. If anything, it was an oddity, it was an exception. Cole's work on the Russian law was trying to call attention to how the state's attempts at regulation are very often synonymous with attempts to control the freedom of religion sphere. And also he was pointing out how the abuse of discretion is probably the most important abuse of powers states can commit towards religious minorities. From comparative work around this time, Cole actually introduced a very interesting visualization of religious freedom on the one hand and church-state affairs on the other. It's very important that this is a two-dimensional visualization because then it meant that the picture fit law books very well. Instead of treating church-state relations on a continuum, Cole suggested that we think of it in terms of a loop, that at the two ends of the loop, too much as well as too little state interference is equally harmful for religious freedom. On the side, he introduced a new dimension as well. That was the dimension of state neutrality in matters of religion. Over the years, the loop started to include many more steps to signify the types of abuse that states committed when they were exercising their powers to limit religious freedom. By the early decades of the 21st century, Cole's work started to focus on what others very often call the culture wars, or even more dramatically, the conscience wars. In an important lecture that he delivered at the Pontifical Academy, he called this period the odd crisis. The crisis, according to Cole, was odd because what we were witnessing during the conscience wars was not really a frontal attack on religious freedom, rather a pattern of erosion by exception. Exception that was introduced to perfectly ordinary and sometimes very civilized pieces of legislation on equal protection or in other mundane administrative rules with the purpose of furthering various types of liberties. This was a very odd take on what caused the crisis, because most of the scholarship focused on blasphemy prosecutions, the headscarves debate, and then ultimately the twists and turns of rights and claims for protection for sexual minorities that very often limited the rights of religious believers. Cole's work pointed out how in this period of the culture wars or conscience wars, or rather during the odd crisis, religious pluralism turned into extreme, or what he calls poisonous polarization. In my own work, I like to think about this period as human rights arguments being used in terms of non-negotiable absolutes to the detriment of liberties of all. Cole's point about poisonous polarization replacing pluralism was underscored by very important social science data that he was deeply familiar with. And in his work, he draws attention to both the steady increase in government restrictions on religion and also on social hostilities involving religion around the world. In the last decade or so, electoral support for populist and illiberal political leaders can be added to this list. It's all the more troubling because the instrumentalization of religion by these leaders fuels religious intolerance, exactly fitting the pattern that the Pew surveys so neatly tracked before these leaders were on the political scene. In a book chapter in 2019, Cole paid a great deal of attention to trying to protect the foundations of what he calls stable religious pluralism. He emphasized the importance of looking at those forces that are formative of poisonous polarization, pointing to fear and a sense of moral panic as chief drivers of really troubling events. In his work, he calls for finding grounds for principled compromise and also for the protection of social spaces and institutional frameworks for the kind of dialogue he has in mind. I believe that the center at BYU is exactly this type of a social space and exactly this type of institutional framework. Over the years, the network of scholars so carefully created under the directorship of Cole and now the directorship of Red Scharffs built a network of scholars, activists, civil servants, international human rights defenders who can actually engage in the type of dialogue Cole had in mind. This dynamic of what it would take to preserve stable pluralism was described by Cole in an essay a lot earlier in the big tome that was the desk book in 2004. He talked about creating social spaces where we find and shape the worldviews of each and every individual in an atmosphere of authentic respect. And this is where I can come to the legacy of Cole's work in his writings beyond the sentence. What I take away from his work is the importance of never getting carried away with the spectacular and dramatic events of the day, and especially trying to avoid larger-than-life metaphors that the sole purpose of which is grabbing the attention of onlookers with zero explanatory potential. From Cole's work, we actually do learn that in order to understand legal change, whether we like it or not, it's very important to trace the building blocks of legal change. That comes with understanding the rules, and also that comes with understanding what it means for those who seek to enforce or change the rules, and especially for those who feel these rules, what these words mean. We have to pay attention to the consequences of seemingly tiny and incremental legal changes, and we also have to understand how the law as applied and how the law as experienced is perceived by those who are subjected to the actions of the state. Cole's work calls attention to the fact that human forces make the law work. And most importantly among these, we have to pay attention to those emotions that are probably in the darker corners of the human nature, fear and moral outrage among them. Seeing these forces as forces that drive those we don't like is something that's not terribly helpful. Cole's own work reminded me over these years that we have to see these forces as the forces that drive us as human beings, all of us. It is understanding how these forces also impact the behavior, the emotions of do-gooders that will enable us to engage in that conversation about fundamentals in the spirit of authentic respect he is talking about. It requires not only reflection and self-reflection, but also humility. The starting point of entering into any dialogue of seeking principled compromises is one of deep humility. It's all the more important as a reminder about where to start when we are engaging with questions that set us apart. When we are engaging on points where our arguments result or potentially result in limiting the rights and liberties of others. Without such self-awareness and humility that Cole's work reminds us of and teaches, there is no hope for finding and awakening the sources of resilience and resistance that will help us withstand the rising tide of illiberal rule. Without his work, we are very likely to forget that what we need in order to stand in the way of forces that undermine the very foundations of constitutional democracy, religious pluralism, and individual liberty, we have to start from the starting point of humility, and this is how we need to engage in a dialogue with others.
Professor Dr. Sophie van Bijsterveld graduated in law from the University of Utrecht. She received a doctorate in law at Tilburg University. She was assistant professor of constitutional and administrative law, associate professor of European and international public law, and professor of religion, state, and society at Tilburg School of Humanities. Since September 1st, 2014, she has been professor of religion, law, and society at the Radboud University in Nijmegen. Dr. van Bijsterveld has lectured and published extensively in the fields of international human rights, religious liberty, constitutional law, and hybrid governance. Among Dr. van Bijsterveld's more than 200 publications are a great number of conference papers delivered in venues worldwide, as well as several books. From 2007 to 2019, Dr. von Bijsterveld was a member of the Dutch Upper House of Parliament for the Christian Democratic Party. She is also a member of the scientific board of the Institute of the Christian Democratic Party in the Netherlands. Professor van Bijsterveld has been a good friend of the Center for many years, including through the course of many years where she was juggling 2 jobs that were each more than full-time, working as a senator in the National Parliament in the Netherlands and also as a party leader, while working as a full-time law professor. In spite of that, she has often joined us to participate in conferences and training programs in far-flung places such as China and Vietnam. She even invited me to give a guest lecture at Radboud University in Nijmegen, and I made her sweat when I showed up late because I had entered the address incorrectly into the GPS. Somehow she forgave me and has remained a good friend. Professor van Bijsterveld, thank you for joining us and helping us commemorate the 20th anniversary of the founding of the International Center for Law and Religion Studies.
I would like to offer my warm congratulations to the International Center with their 20th anniversary, to its leadership, to its fellows, and to all those that support the Center and have done so over the past years. A special word of congratulations to Cole Durham, who has been and still is a driving force behind the Center, and without whose energy, vision, and untiring activity, the Center would not be what it is today. A leading center with global impact in the field of law and religion that brings together academics, leaders in the public sector, and practitioners, and that forges global interconnections, structural cooperation, and understanding. I am grateful for the Center for all those reasons and for the enduring friendships that have been established through the Center, especially with its leadership and fellows. In this respect, I mention Cole Durham specifically again, whom I first met in Warsaw over 20 years ago in the run-up to what would become the advisory panel on freedom of religion and belief of the ODIHR of the OSCE. The topic of this session is protecting religious rights in a way to benefit all, a topic that lies at the core of the Center's mission, to help secure the blessings of freedom of religion and belief for all people. And it's part of an overarching conference theme, rights and responsibilities. In this presentation, I will approach the topic of freedom to benefit all through the lens of restrictions, limitations to religious freedom. I will first sketch a few developments in the domain of religion that pose challenges to religious liberty. I will then sketch a few developments in the sphere of the state that pose challenges to freedom of religion. And these challenges form the background against which the debates on the limitations of religious freedom, rather than the freedom of itself, have become more prominent over the last years. They also form the background against which I will offer some thoughts that may help legislatures in weighing religious rights of individuals and groups against the public interest. And my experience is shaped by the law and politics, by the social and religious reality of Western European countries, and specifically the Netherlands. And that is the context of my reflections today. First of all, it is important to remember that freedom of religion and belief as a human right is a way of articulating human dignity in a concrete, legally relevant form. Human rights are not simply nice legal instruments. They are informed by a deeper value. And seen from a social perspective, guaranteeing freedom keeps the debate open on what is the good life. Thus, it also serves the common good. And it also helps to enable people to live together peacefully in an enduring way, even if they have fundamentally different views.
And until recently, freedom of religion and belief was by and large self-understood. In recent decades, a number of developments have caused a change in this awareness and in the social perception of religion. The first is an effect of the ongoing process of secularization. Simply less people have first-hand knowledge or experience with the practice of religion or with religion as a social phenomenon. The second is that the visibility of religion in the world has increased in those same decades. But unfortunately, this visibility predominantly concerns the pathology of religion. That is, this visibility mainly relates to religiously related or religiously motivated violence and social aberrations. The third development is, in my opinion, a faulty, or at least a strongly reductive, one-sided assessment of what religion is really about. Due also to the absence of first-hand knowledge or experience with religion, religious belief often seems to be equated with a set of beliefs, usually beliefs in a set of rather antiquated statements that seem rather implausible, rather than a way of being in the world, a commitment to a way of life, and a guidance concerning what is ultimately important. And as a result of these three, and perhaps other developments, religion is no longer self-evident, and the support and the sympathy for it has, generally speaking, not increased. And that poses a challenge to freedom of religion. And it's an interesting question, by the way, what contribution religious leaders and religious believers in general can make to counter these views and to highlight the value of religion and its contribution to society. But another set of challenges lies in the domain of the state. As the American scholar Fred Gallix has pointed out, it has become more difficult for modern states to guarantee religious freedom as freedom, simply because of the fact that modern law covers practically all aspects of life. Taking into account religion and respecting everybody's liberty by creating exemptions to the law has become more difficult, certainly in strongly pluralist countries. Rather than through liberty, religious freedom tends to be guaranteed through equality. And that is not necessarily bad, but it is different. The second development in the domain of the state is that the state, through its democratic system, responds to value changes in the society. And values in society, of course, have always been open to change. And when values themselves do not change, their relative attention or their priority may change. We see, for example, that equal treatment in practically every sphere of life has gained more attention. And the same is true for the value of privacy or physical integrity or the value of animal welfare. And these values in themselves are such that everyone can subscribe to them. They are legally protected in their own right through the Constitution or through ordinary legislation, and for good reasons. At the same time, they form the context against which debates on certain religious practices take place. For instance, religiously motivated male circumcision, or where animal welfare is concerned, debates about ritual slaughtering. A third development is religious pluralism due to immigration from cultures that differ substantially from those of Western liberal democracies. Social practices and religious or cultural convictions, if professed by a large enough number of people, run the risk of placing under pressure what are seen as hard-fought liberal achievements in the sphere of, for example, male-female relationships, attitudes towards sexual orientations, critical speech with regard to religion, or with respect to the values of liberal democracy itself. As a result, the law is less open to relativize in these particular areas, even if particular views or practices are shared by traditional, well-integrated religious minorities. These combined developments in the field of religion, state and society challenge religious freedom. And as a result, debates on religion take place in the perspective of debates on limitations of religious freedom rather than the freedom itself. How then to approach the issue of limitations to religious freedom? Of course, each national constitutional law has its own method of balancing religious rights against other interests. And in the European sphere, there is, of course, the European Court on Human Rights with its well-established case law on how to assess whether a particular limitation to religious liberty falls within the parameters of the guarantees of the European Convention. But before a case reaches a court, if ever, there is a weighing process in which the national legislature is involved. And the national legislature always has room for maneuver. I would like to offer the legislator 3 suggestions. First, as the cry for limitations is often incident-driven, there is a natural reaction to advocate limitations that are both too extreme and at the same time not effective. My advice is, take time for reflection and, if necessary, employ a method that is both targeted and proportionate. I will give an example. In the Netherlands, signals suddenly emerged that jihadist recruitment was taking place in Islamic schools. And the first reaction to this intolerable practice was to advocate the introduction of state inspection to religious lessons in confessional schools. And how well-intentioned it might be, a measure like this would be too extreme and at the same time not effective at all. Not effective. For truly countering jihadist recruitment, simply having religious lessons inspected will not suffice, even in case of constant monitoring, which is unfeasible anyway. At the same time, it would be too far-reaching. It would affect all confessional schools, including Roman Catholic and Dutch Protestant, where we may safely assume no recruitment for the jihad takes place. To make an analogy outside of the field of religion, the Dutch state was concerned about so-called fake marriages, a vehicle for improper immigration and misuse of social security. And it employed tailor-made ways to counter this undesirable phenomenon, instead of checking each and every bridal couple's marriage motives. That would be too extreme and at the same time not effective. A second advice. In order to meet legitimate concerns, limiting religion is not always the answer to the problem. Sometimes it's better and more effective to choose another anchor for action. To stay with education as an example, there have been worries about the functioning of some confessional schools in the Netherlands, predominantly in the Islamic field. But rather than questioning the right of existence of such confessional schools, offering or requiring management training or professional qualifications may be more helpful. And the same is true for attaching financial benefits to particular qualifications. Of course, such measures are no solid guarantee that nothing will go wrong. But the point is that it is fruitful to investigate whether there are other ways of really tackling the problem. And there may be even alternatives to legislation itself. A third advice relates to value changes in society, as a result of which long-standing religious practices within a country have become controversial. I already mentioned diverse practices such as ritual slaughtering or religious male circumcision. My advice to the legislator is, do not outlaw long-standing practices overnight, simply because there is the democratic power to do so. That is too crude an instrument. In the same line of advice, views and practices that used to be the majority but have become minority preferably should be respected, if at least logically possible. Thus, peaceful value changes are legally supported, while minority views are respected if possible. What do we gain with this advice? By following these three proposals, not all problems can be solved. Difficult issues will always remain, but they can help in particular circumstances to secure liberty and at the same time curtailing practices that are seen as problematic or intolerable from a point of view of liberal democracy. And it also enables the law to respond to changes in values in society without alienating long-standing minorities. To summarize, a combination of factors in the domains of religion, state, and society cause a focus more on limitation rather than liberty of religion. Limitations as such are nothing new. They spring from the general ordering of society, and they can be specifically created for legitimate purposes that basically aim at the well-being of others. But in creating these limitations, a legislator should be thoughtful and have both targeted and proportional limitations, not those that are too extreme and at the same time not effective. Second, religion as a focal point is not always the right way of achieving the desired results. And third, in considering limitation, legislators should, if logically feasible, be considerate to long-standing minorities whose views used to be the majority. Thank you.
Professor Dr. Faizan Mustafa is the Vice-Chancellor of NALSAR, University of Law, Hyderabad, India. He was the founder, Vice-Chancellor, of the National Law University, Orissa. He has served as Dean, Faculty of Law, Aligarh Muslim University, and Registrar of AMU. He is a gold medalist LLM from Aligarh. He completed his PhD in copyright law. He also has a diploma in international and comparative human rights from the International Institute of Human Rights in Strasbourg, France. He has authored several books and some 100 national and international papers. He has worked in unexplored areas such as religious conversion laws, strict liability law, and freedom of information law. Dr. Faizan is a prolific and courageous public intellectual who writes regularly in the popular press, often taking unpopular positions in defense of freedom of religion and belief. He is also our close partner and friend in developing the field of law and religion studies in India. We are extremely grateful for our association with him and are honored to count him as a friend.
Hello and good afternoon. First of all, let me express my gratitude to Professor Elizabeth for giving me this opportunity to talk to each one of you. And I must also place my appreciation and gratitude on record for Professor Cole Durham, who has now retired from BYU and who has helped me in developing more and more interest in religion and law. I met him for the first time in Australia, and then we were together in Turkey and Germany. And this year, till early March, he was teaching a course at NALSAR University of Law. So he was able to get out of India well in time to reach United States. Otherwise, in next 2 weeks' time or so, we got a national lockdown. I think he has spent a lifetime in developing this center, and his services at BYU will be remembered for long. And he himself indeed is a scholar in his own right, a leading light of religion and law discipline. Now, the topic on which I am going to talk about is rights and responsibilities of the majority and the minority religion. And since we are living in unprecedented times of COVID, I would also look at some of the recent developments in India about the minority religions. Now, we live in strange times. When I was a student or doing constitutional law for many, many years, we always talked about the minority rights because, as Chief Justice Lethman of the Australian High Court had said, that the success of a democracy depends on the amount of protection enjoyed by the minorities, as the majority can take care of its interest on their own. But lately we see, not only in India but elsewhere, majorities are having some sense of victimhood, and it is presented as if the majorities are under threat. So be it a Muslim majority in Pakistan, which feels threatened by Ahmadiyyas and by the insignificant Christian and the Hindu population. The Hindus in India feel threatened by Muslims and Christians, and whites in United States of America feel threatened or presented to be threatened by blacks. So let me look at this whole question of minority majority thing in the Indian context. If you look at our demography, Hindus are 80%. They will forever have the majority status. Muslims are about 14%. Christians are just 2%. In spite of a claim which is being made by the Hindu right all the time that the Christians are converting tribals, into Christianity, the number of Christians over decades has not gone up. Similarly, the fertility rate of Muslims has seen the steepest decline in last census, and it would be impossible for Muslims to ever overtake Hindus in India. Yet this is a kind of propaganda which goes on. As far as the Constitution of India is concerned, we don't have a non-establishment clause. Indian Constitution believes in equidistance from all religions. Our preamble did not start with word God, even though there was a proposal. Of course, we did not start with word secular either, which was inserted in 1976. And the Hindu right is very, very unhappy about this word secular, and they make fun of this word, and they think that Hindus are at the receiving end because India is a secular country and they want to turn India into a Hindu Rashtra or a Hindu theocracy. If you look at the Constitution, word Muslim is not there. Word Hindu appears at number of times. If you look at in terms of symbols, the Hindu temples have been talked about. In fact, in a secular Constitution of India, there is a provision that every year certain amount will be spent on the maintenance of certain Hindu temples. There is a specific provision about the protection of cow. And you know, we have seen in the recent past number of mob lynching cases because of the alleged slaughter of cow or alleged possession of the beef. Similarly, there is a recognition of Sikhs because there is a mention in our freedom of religion article that Sikhs will be allowed to keep their kirpan, which is otherwise a weapon not allowed in flights and other places. Christians are also somewhat recognized in the sense that in the original freedom of religion article, word propagate was not there. And when the Christian members of our Constituent Assembly insisted that this word is crucial for them, that word was eventually inserted. If you look at the definition of word Hindu, it includes even other religions like Sikhism and Jainism and Buddhism. In fact, the Jains had protested so much on the commencement of the Constitution on 26th of January 1950 to the then Prime Minister Pandit Jawaharlal Nehru that he had to reply them that we will rectify this mistake. And it took decades and decades for Jains even to be recognized as a minority. But as far as law is concerned, our constitution does not recognize Hinduism, Sikhism, and Jainism as independent religions, while these three religions keep asserting that they are different from Hinduism, though of course they originated in India. And this kind of divide between the religions which originated in India and the religions which originated outside is responsible for all the polarization in India. And Christians and Muslims and Jews, of course, their religions originated elsewhere. So Hindu right keeps saying that their sacred places are not in India, while India may be their motherland, but India is not their sacred land. This is how they present their argument. Now, if you look at the Supreme Court, even prior to insertion of word secular, Supreme Court's largest bench, 13-judge bench, said India is a secular country. Secularism is the basic structure of the Constitution. Mr. Keshavanand Bharati died just 2 days ago. Yet, in terms of Constitution, most of the fundamental rights are available to all citizens. We have a non-discrimination article. We have a freedom of religion. We have a freedom for religious institutions, which is available to every citizen, whether you belong to a majority religion or a minority religion, it doesn't really matter. But there is one right which has been subject of lot of criticism by the Hindu right, and they say that it is the appeasement of the minority religions, and this is a right whose heading is protection of interest of the minorities. But in the text it is written, any section of Indian citizens having a distinct language, script or culture of its own shall have the right to conserve the same. And therefore this is a right again of every citizen. The other important right is Article 30 of our Constitution, which says minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. Now, since Indian provinces or states were made on linguistic basis, so people who are Hindus living in North, when they come to South, they become a linguistic minority and they are entitled to the benefit of this article. Yet this article is presented as if it is doing some undue favor to the minorities. And the BJP's, there was one committee to look at the review of the Constitution, K.R. Malkani committee report, which said that this article should be deleted. One other article on freedom of religion, which is available to all citizens, is about owning immovable and movable properties. And here the argument of the majority religion is that the Hindu religious and charitable institutions are under the excessive control of the government. As you know that the Hindu temples have lot of money. One temple in South, which is about 500 kilometers from my place, at Tirupati, it has now overtaken Vatican in terms of the revenues it generates in a year. And since there is lot of money, there have been allegations of mismanagement of that money, and therefore number of laws have been passed to look at the secular activity of the temples in terms of how these huge amounts of money are spent. And this Hindu right says is violation of their freedom of religion, because the minority religious are not subjected to this kind of state control. Now, the minority mosques don't receive offerings in terms of money and the gold and diamonds as Hindu temples receive. Similarly, minority churches do not receive that kind of offerings. In any case, whether it is Muslim religious properties called waqfs, there have been as many as 27 legislations passed about the waqf properties. And in terms of waqf properties also, you have a similar or greater state control. Similarly, we have Shiromani Gurdwara Prabandhak Committee Act about the Sikh shrines, and there is a control of the state about the Sikh shrines as well. Recently, there was a law passed in one of our states about 4 sacred places, and it said that a board will manage these shrines, and it was challenged. The High Court said that the law is valid, and this whole argument of the Hindu right is not right. In spite of a promise by the Prime Minister Narendra Modi's government, and they are on the same page on this issue. In last 6 years, the Modi government has not taken any initiative in terms of enacting a law on the lines demanded by the Hindu right. Last year, we also saw a major historic judgment about the Babri Mosque. Now, this mosque was constructed way back 1528 by the Mughal Emperor Babur, and it continued as a mosque till 1949. In the 19th century, when the British took over the control of this part of the country, they continued the government grant, which was coming in from the Mughal period and from the Awadh Principality. And in 1949, within a month of even decision of adoption of the constitution, there was illegal installation of Hindu idols. And then the mosque was closed. Thereafter, no prayers were held. Recently, the Supreme Court has held that this was an illegal act. And then in 1992, the mosque in a broad daylight on 6th of December was demolished by the Hindu mob. And Supreme Court has also written in its judgment that that decision itself was also an illegal act, and it was negation of rule of law. We had also enacted a law called Places of Worship Act, which said that whatever is the status of any place of worship on 15th August 1947, when the country got freedom, that status will not be changed. This is a 1991 law, but we had kept Babri Masjid dispute out of it. To my surprise and shock, the Supreme Court of India in November 2019 gave a judgment, and they said that Muslim parties were not able to prove the possession of this property. And since they could not prove the possession of this property, they decided in favor of the Hindu party on the basis of no document or no evidence, but just their mere beliefs that this is the precise place where Lord Rama was born. Now, ignoring evidence law, ignoring law of possession and ownership, the Supreme Court preferred to go by the beliefs of the majority community. And that, I think, had somewhat disappointed the Muslim parties who were fighting this case. Of course, this was a long drawn controversy. In between, there was, after the demolition, even ordering of Archaeological Survey of India digging of this site to look at the central argument of the Hindu right that Mughal emperor had demolished the temple, Lord Rama's temple, to construct this mosque. But the ASI report, the Archaeological Survey of India's report, did not find any evidence whatsoever of demolition of Lord Rama's temple. So neither there was archaeological evidence nor there was any legal evidence, yet this mosque was converted into a temple, and the Muslim parties for a reparation of 1949 illegal installation of idols and 1992 demolition of a mosque have been given a piece of land some 25 kilometers from this site to construct their mosque. Now, people who were involved in demolition, it was a criminal act. They have not yet been punished all these years. It has been 28 years, not a single conviction. Number of times the matter has gone to the Supreme Court, and Supreme Court has directed that this judgment should be quickly given. Now the deadline is coming to an end by the end of this September. Let us hope that finally we will get some lower court judgment. Of course, the matter will then go in appeal to High Court and then to Supreme Court. And some of the accused are already in their 90s. So I don't think at the end of the day anybody really being punished. Maybe some Muslim rulers in medieval times demolished temples or demolished churches, but in a democracy, in a broad daylight, in a rule of law, we saw it through our eyes, how a mosque, which was the only surviving piece of Sharqi architecture in a broad daylight, was brought down by people rather than some arrogant ruler. And that was really frustrating. Then in the context of the COVID-19, again, the minorities were targeted, particularly the Muslims. We have a Muslim community called faith travelers who leave their places, go all over in the world, and they just want people to become more religious, and their focus is more on worship. And these people who had come on valid visa from about 81 countries, they got stranded in the center of this community center in Delhi. And because suddenly the national lockdown was announced, and then it was said that they are violating the law, because the law now says that there will not be collection of more people at one place due to COVID-19. And many of them are in jails for almost 6 months. Many of them have tested negative, and they have been charged for spreading coronavirus. Recently, the Bombay High Court has said that these people have been targeted for their faith, and these people have come on valid visa, and the visa condition nowhere prohibits attending a religious congregation. And since they were themselves negative, how can they spread coronavirus anywhere? In any case, it was a huge place which had all the residential facilities, and because of the lockdown, they couldn't move out from there, and most of them are now getting acquitted, or the charges are getting summarily dismissed through the intervention of our judiciary. Now, there have been attacks on churches. When President Trump was here in February, there were riots in the national capital in the presence of the United States President, who was our most honored guest, and people were killed, and there is a kind of a biased investigation. Number of questions have been raised about the neutrality of the police during COVID-19 also, while religious congregation was prohibited, but Muslim azan was not prohibited. Yet in many states, the mosques were not allowed to have azan. I am not a great votary of azan on loudspeakers, but there are municipal rules which permit that you can have speakers with this much of permissible decibel noise which you can make through azan. Yet there was some kind of controversy about even Muslim azan. Then the government of India has also come up with Citizenship Amendment Act, which has been criticized by the United States Commission on Religious Freedom. There was a hearing held in February in United States. Now this law says that people who have come from Pakistan, Afghanistan and Bangladesh, if they have lived in India for certain number of years, they will be given citizenship except Muslims and Jews. Now, this law is absolutely discriminatory. It discriminates only on the basis of religion and on the question of persecution of minorities in Pakistan and Bangladesh. I am not denying it. The way Pakistan's blasphemy law is, it is absolutely discriminatory. The way Pakistan treats its minorities is absolutely discriminatory. But Pakistan is not our role model. But to say that we are passing this law because of religious persecution, we find in the law word religious persecution has not been used. And in Pakistan, there are Shias who are also similarly persecuted. There are people of Ahmadiyya sect who are similarly discriminated and persecuted. Why we are not giving citizenship to even all the persecuted people of even these three countries and the persecuted people in our neighborhood? We have Hindus in Sri Lanka, Tamil Hindus, who are persecuted by Buddhist Sinhalese. We have Hindus who are discriminated in Bhutan, because Bhutan is a predominantly Buddhist country. And of course, in Myanmar, we are having a genocide, which has already been recognized even by International Court of Justice. Yet we do not want that Muslims who are under severe religious persecution in Myanmar should be even given shelter in India. So you have all round, scenario where people belonging to minority religions are at the receiving end, whether you look at the arrested people under terror laws, anti-terror laws, UPA or TADA or POTA, and you will see that the conviction rate in these laws is less than 1%. But it takes people years to get their innocence established, and their life, their family's life get completely destroyed. And then we are also coming up with what is called National Population Register. And in that register also, many people who may not have documentary proof of their citizenship may be excluded. And therefore, we are going to have a huge crisis. In one of our states, already 1.9 million people could not find their names in the citizenship register because of just absence of some document. And that is against the international conventions which say that you should get the citizenship of place where you are born. So just to conclude, I would say that this whole argument that minorities have been appeased in India is a bogus argument. It has no substance. If you look at the share of minorities in the state jobs, in the powers and positions of the state, today, Muslims have the lowest representation in our lower house of the parliament, which is the main house, which has all the powers in parliamentary democracy, like House of Commons in Britain. There was a provision for the nomination of Anglo-Indians if they are not adequately represented. That provision is also being removed, and there are increasingly demands that India should also become a Hindu theocracy. Of course, I had written that the supporters of Hindu theocracy will get disappointed once India becomes a Hindu theocracy, because we cannot become a theocracy like Saudi Arabia or a theocracy like Iran. We have to become a theocracy like Great Britain or Greece, where you will have a jurisdiction model of secularism. Maybe there will be a state church, maybe Queen will be a defender of faith, maybe we will acknowledge the Hindu cultural heritage as our dominant heritage, yet all minorities will continue to be Indian citizens, and a non-discrimination clause will remain in the Constitution. So finally, just to conclude, I would say that we need to realize that giving religious freedom to minorities and also to the majority is not going to harm the nation. Rather, it is going to help everyone and benefit everyone, because we, as is said, that Indians are essentially religious. If we do not give this freedom to them, people will feel suffocated, and it will not, they will not have harmony and peace in the society. So if a multi-religious society like us has to survive, then we must celebrate our diversity. We do not go by American theory of melting pot. We go by the salad bowl theory, where the distinctive identities of all Indian religious communities must be preserved and must be celebrated. If we guarantee freedom of religion, I am sure we will be able to create an upright, honest, humane, and more caring society. Thank you very much. And thank you, David, very much.